It's very satisfying to help people. I just can't imagine a better job.
Good afternoon, everyone, and thank you for joining our Zoom side chat today. We're going to be talking about Medicaid Trust. I'm Michael Ettinger from Ettinger Law Firm, and this is one of our series of 6 Zoom side chats, including components of an elder law estate plan, the 5 steps to an elder law estate plan, some selected topics such as second marriage planning and planning for adult dependent children, a couple other things. But today, the Medicaid Asset Protection Trust. I think we have everybody aboard. Just by way of preliminaries, there's a Q&A button at the bottom of your screen. If you have a question, please type it in there at the Q&A at the bottom. We're going to take all the questions at the end. I hope you can stay for the lively question and answer session, and including the ones that were sent in ahead of time. I'm going to go right to the slides. Well, actually, one more thing. I just want you to know, you're going to get a copy of this presentation later this afternoon. You'll get a copy of the recording. As some of you may know, I'm the author of the book, Elder Law Estate Planning, but knowing that not everybody wants to read a whole book or has the time to, as my thank you for joining us today, we're going to send you a copy of the condensed version of my book. It's called Elder Law Estate Planning in a Nutshell. It's a 4-color e-booklet. It comes by email, and that will also come with a copy of the recording. The slides I'm about to put up, you got a copy with a confirmation of this email, so you can look them over later. But today, probably just you're welcome to just follow along. So I'm going to share my screen now and pull up the first page. This is one of a series of 6 Zoom side chats. Today, we're going to protect our home and life savings with a Medicaid Asset Protection Trust. The MAPT is the acronym. There's our website, trustlaw.com. Hundreds of pages of information on elder law estate planning. That's me in the middle of the top row. To my left is my lovely wife and law partner, Suzanne Ettinger. Our practice for 31 years has been limited to elder law estate planning, and that consists of trusts and estates, wills and probate, estate tax saving strategies, Medicaid asset protection trusts, and Medicaid applications. We have offices in Nassau, 2 offices. We have 3 offices in Suffolk County. That's 5 on the island. We're in Brooklyn, Staten Island, Westchester. We're in White Plains at 140 Grand Street. Rockland used to be in Nyack, just moved a couple months ago to New City, 345 North Main Street. In Orange County, we're in Middletown. In Dutchess County, we're in Fishkill and Rhinebeck. In Albany, we're right on Wolf Road, and in Saratoga on Broadway. So let's go right into the topic. If you just joined us, again, there's a Q&A button at the bottom of your screen. If you have a question, go ahead, please, and just type it in, and at the end, we'll take all the questions. So we're going to take an overview of the Medicaid Asset Protection Trust by explaining what trusts are. A trust is a legal entity that allows you to separate the use and enjoyment of property from the bare ownership. So assets you want to protect, like your house, are retitled to the trust, but as the trust beneficiary, you have the use and enjoyment of the trust property. So you have exclusive use and enjoyment. Remember, we could separate that from the bare ownership. It's the same as if you deeded your property, your house to your children, reserved the right to live there. You have the use and enjoyment, they have the bare ownership. But essentially, while you have the use and enjoyment, you're not the technical owner. So the bare ownership resides with the trust, which is separate from you. This is the Medicaid Asset Protection Trust that owns the property. It's separate from you. It has its own Social Security number, known as a trust tax ID number, a TTID. There's the lovely house we're trying to protect. So if something happens to you personally, like you need care at home or in a nursing facility, they can't get the asset because you don't own it. Of course, as a look back period, we'll get into that. And the trust has been called the greatest invention of the English common law. This idea that you could separate the use and enjoyment of something and keep the use and enjoyment without having the ownership. So now we get right away to the 5-year look back for facility care. And it means Medicaid can look back up to 5 years. And why do they have the look back? Well, if they didn't have the look back, people would just wait until they needed to go into a nursing home, move everything out of their name a few days before, and then say, I'm here, take me, I don't have anything, I'm eligible. So the look back means they can look back on anything you transferred out of your name into the trust for up to 5 years. But it's not an all or nothing rule. Let's say you make 4 years from the time you transferred assets to the trust, you only have to pay for the 1 year that's left. I'm going to explain how that works technically. Let's say a client comes to us and they move the assets out 4 years ago, or they're a client of ours, they moved the assets 4 years ago. They come in and they say, we need care in a facility. We'll say, well, you're not eligible because you've made transfers in the last 4 years. It has to be 5 years. So what you have to do is you have to private pay for the 1 year that's left. And there's ways to get money out of the trust for that purpose. If you need it for private pay, you can gift it out to your children and they can pay the facility. They can't give it back to you, but they can pay the facility. So you pull out enough to pay for the last year. Lo and behold, 5 years go by. Now we apply for Medicaid. Remember, we private paid for the last year. Now we apply for Medicaid. The question on the Medicaid application is, what have you transferred within the last 5 years? The answer is nothing, because you apply more than 5 years after you made the transfers. And in fact, you can apply if you made transfers within the last 5 years, because you're not eligible. That's why we don't apply. We wait till the 5 years has passed and then we apply. And because of COVID, possibly moving it to January 1 of 2022. Not sure about that. I haven't got a definitive answer on that yet. They're talking about it, but nevertheless, it's coming. Sooner or later, it's coming. And the 2.5-year look back, right now, it's starting July 1, and it's for 30 months, which is 2.5 years, but it's not all starting on July 1. It's phasing in. So they're adding 1 month of a look back every month until the end of 2023, which is 2.5 years later. After then, it'll be the full 2.5 years. So in August, it'll be a 1 month look back. In September, it'll be a 2 month look back, et cetera, until 30 months have gone by. So it's being phased in. But this makes the Medicaid Asset Protection Trust an essential tool for those who want to age in place. Everybody wants to be able to stay in their own home, but if they have to spend all their money paying for home care, they may not be able to afford it. So we want to shelter that money, make them eligible for Medicaid, and they have that money either for their heirs or for additional needs. Without the Medicaid Asset Protection Trust, a lot of people are going to be unable to afford care at home because they can't pay the caregivers and the costs of running the house, and they'll be forced to sell their homes and use the money to pay for assisted living. This is going to be a problem for people, especially people who don't know about it and don't plan ahead to avoid it. What we want to do is shelter the money so that we're eligible for Medicaid benefits. We can afford to carry the house with our income and have the home care paid for by the Medicaid program. And why is home care so important? Because a lot of people use their spouse as the caregiver, and a lot of spouse caregivers die first from the strain. Remember, it's a 24/7, 365 job. It's a hard job. The caregiver, the spouse, is not even trained to do the job. And again, many of the caregivers die first or end up in the hospital from the stress of the 24/7 job. We don't want that to happen. We want to make you eligible for people to come in the house and help. Why set up a Medicaid Asset Protection Trust? Well, all trusts avoid probate at death, and probate's a legal proceeding to prove the will valid. So tomorrow I give a seminar on all of elder law estate planning. And in my seminar, I'll talk quite a bit about probate and what it's like and why the general public wants to avoid it. I saw someone raise their hand. I can't take questions during the seminar, but there's a Q&A section there. If you have a question, type in your question and we'll take it at the end. For those that have just joined us, Looks like a couple of late stragglers. I'm just going to go back and just quickly I was just talking about the Medicaid Trust as a 5-year look back for home care. There's a 2.5-year look back starting on July 1. And that's where we are now. Why set up a Medicaid trust? Well, all trusts avoid probate. So even if you don't have to go to a nursing home or you don't need home care, it still saves a lot more than it costs because you avoid a court proceeding at death. Someone called probate like a lawsuit that you start against yourself. Remember, there's nobody on the other side, but for the will to be proved valid, you have to go to court. The executor has no power until the court has decided. So it's essentially a lawsuit that you create by having a will. What are your other options to setting up the MAPT? Making assets joint with the children? That doesn't work. Medicaid considers the combined assets of the joint owners as all being available for the care of the ill person, except to the extent the other person can prove the amount of their actual contribution. So put it another way, just putting son or daughter's name on an account doesn't save half of it. Medicaid says it's all yours unless they put money in, and 99% of the time they didn't put money in. Assets joint with the spouse are all available for the care of the ill spouse because Medicaid considers spouses as one unit. What about putting your assets in your children's names? A lot of people do this and regret that they ever did it because you're running the risk that they might incur debt, a bankruptcy, a large medical bill, a personal injury that they caused somebody, sued for something else. So you're subject to all their debts and liabilities. What if they get divorced? Your son-in-law or daughter-in-law can walk away with half your assets. So not a good idea. And what if you need it back later on? They may have spent it or they won't give it back. All of these things have happened many times to many people. There's no protection. This is basically amateurish. People do this because they don't have good advice and they don't know what their options are, and they don't know there's a better way to do things that protect the assets and protect them. And finally, you put in your son or daughter's name, they die before you, it ends up with their children, and you're never going to see it. And they can be minors as well and be tied up in court with legal guardians. A whole host of problems we want to avoid. That's why we use trusts instead of putting it in the children's names. And as I said earlier, you can't transfer it to your spouse to protect it because the combined assets of spouses are available for the care of the ill spouse, regardless whose names they're in. Now, that's the rule. But in New York, we have an exception. It's called spousal refusal. And that occurs if husband, let's say, it could be wife, but if husband has to go into nursing home, move all the assets into wife's name, she signs a document, it's called a spousal refusal, saying, I need these assets for my care, and I can't afford to contribute to my husband's care. If you sign a spousal refusal, by law, they have to give the husband Medicaid, but they have a right of recovery from the wife. They can go after her in family court for support. Now, it's still better to use spousal refusal because Medicaid pays a lower rate than the private person pays. There's a private pay rate and the Medicaid reimbursement rate. Medicaid reimbursement roughly a third less than the private pay rate. So if you refuse and Medicaid has to pay, they can only come after you for what they pay, which is much less than you would have had to pay. So already you're saving a third. Sometimes they don't come after you, but when they do come after you, we can negotiate a lower amount. So it always pays to go spousal refusal. Now, the Medicaid Asset Protection Trust is known as an income-only trust, and it means what it says. If you put in stocks, you only get the dividends. If you put in CDs, you only get the interest. If you put in your house, you get the equivalent of the income, exclusive right to live there, use and enjoy that property during your lifetime. What happens to these assets? They stay in the trust, and they go to your heirs, free up the expense and delay of probate. Now, a couple of principles that make the trust work. It's an irrevocable trust. And that is because in a revocable trust, there's no nursing home protection because you could take it out at any time. You're in charge of a revocable trust. In an irrevocable trust, you put somebody else in charge, usually one or more of the adult children, and Medicaid has no control over them. So if you were in charge, they say, well, you can get it, take it out and give it to us. But if you name the children, Medicaid has no control over the children. They can't make them take it out. So you limit your access to principal by naming somebody else besides you or your spouse's trustee, again, one or more of the adult children. Because as I said, if you can get it, they can get it. This way, you can't get it, they can't get it. And income only is dividends on stocks, interest on CDs. The trust is ideal for assets you're not spending, like your home. For heaven's sakes, move to protect your home. What happens if you own a home and you end up needing care in a nursing facility? They put a lien on the house, and pretty soon at those rates, the lien gets bigger in the house, and eventually Medicaid walks away with the house. Every day, Medicaid walks away with people's houses all over New York, and it's totally unnecessary. For more than 30 years, you're allowed to take the house, put it into the Medicaid Trust, and anytime after 5 years you need care, they can't touch it. It's really a no-brainer. There's no downside. You keep all your exemptions on the house. You want to sell the house, the trust sells the house. Trust buys a condo, and the name of the trust is already protected. You already have your 5 years. So of course, protect the house, no downside. What about other assets? Certain assets are exempt from Medicaid. IRA, 401k, 403b, exempt. It's true, if you're over 72, you have to take the required minimum distributions. They get those, but they can't, that might be $2,000 to $3,000 a month at most. They can't go into the IRA itself and get the rest of that $18,000 a month that the nursing homes charge, because the IRA itself is exempt. They can only get the RMD's required minimum distribution. But what about assets that are not IRA, not protected? So non-qualified. IRA is called qualified, deferred to 72, non-qualified. A lot of people come into the office and they have a nest egg. Let's pick a number, 500,000. A lot of clients tell me that they don't need the 500,000 to live on because they have enough income. It's extra money just in case. A lot of other clients say, well, we're not spending the 500,000, but we're taking the interest or dividends. Well, fine, the trust gives you the interest or dividends, but you realize if you have a nest egg that you don't need to live on, you're actually safekeeping it for the nursing home industry. So we want to protect those assets. We put those assets in the trust. There's some access to them. You get the income. There is a way to get principal. I'm going to talk about that in a moment. But essentially, when you set up an MAPT, it doesn't affect your lifestyle. Still get your pension directly, your Social Security, interest, dividends, your required minimum distributions. You have the exclusive right to use and occupy the primary residence under the trust. Remember I said the trust separates use and enjoyment from the ownership? You don't own it, but you have the exclusive use and occupancy. You have life rights, like a life estate. You keep your exemptions on the property, senior, veteran, star. You have an investment account, let's say with Morgan Stanley. We put it in the trust. Now your son or daughter's name is on as trustee, but they can sign a third-party authorization, say, I authorize dad or mom to trade on the account. You can still run it. If you do your online trading, they take out a PIN, they give you the PIN, and you can go on yourself. Now, we don't like to give up control. We want to keep control. So you reserve the right to change the trustee at any time. This is your control. They're in charge of the trust, but you're in charge of them. So you have a falling out, you don't like how they're handling it, you can fire them and put in somebody else. We will help you do that if you need to. As I said, you can sell the house and buy a condo. It doesn't start the look back period over. Trust can buy and sell and trade stock. It's very flexible. IRAs, other qualified plans, exempt from Medicaid, so we don't put them into the MAPT. They're also exempt from probate. Remember, IRAs and other qualified plans have a designated beneficiary. It goes right to the person named. But if you want to sell your house, you may be aware that you can exclude the capital gains taxes on $250,000 of gain if you're single, $500,000 of gain if you're a couple. That the trust preserves that exclusion, so you keep that if you sell the house, if the trust sells it. Now, a lot of people are afraid of the word irrevocable, but in New York, you can revoke an irrevocable trust. It's an irrevocable trust because you, the people who created it, called the grantors, you can't revoke it yourselves. But New York has another rule that says if all the parties named in an irrevocable trust agree in writing that they no longer want the trust, you may revoke it on consent of all the named parties. Well, who are all the named parties? You and the adult children. So if everybody signs, you can undo it. Now, what if one of them won't sign? Well, actually, we have a workaround for that. We can take their name out of the trust and they're not a named party and they don't have to sign. So you're always in control. You can always undo that trust. And there's the workaround I was talking about. We can take them out if they won't sign. Let's look at the alternative to the MAPT, which is the life estate deed. What is a life estate deed? A lot of people, and this is people who see a general lawyer or a family lawyer, a real estate lawyer, they say, oh, you can protect your house by deeding it to the children, reserving the right to live there. Well, that's what a life estate deed is. You deed it to the children, you have life rights. Now, if you have to go into a nursing home, there's a drawback. If the house is sold prior to death, the life estate, generally around 50% of the value, according to Medicaid, goes to the nursing home. So you can't sell it. If the house is rented, the life tenant is entitled to the rents because they have life rights. So the rents go to the nursing home. If the house is sold during your lifetime, you also lose a big part of the capital gains tax exclusion I just mentioned, $500,000 for a couple, $250,000 for a single. You don't own the whole house. You only own about 50% with the life estate, so you lose 50% of the exemption. So what happens is mom or dad has to go into a nursing facility for a few years, and you can't sell the house and can't rent the house. You can end up carrying a vacant home for years. The trust basically solves that problem because the trust can buy and sell assets. The trust can sell the house, get the money and invest it. We mentioned you keep your property tax exemptions. Control, you can change the trustee at any time. You can change who you leave it to. So I'm always amazed when I see somebody come in with a Medicaid trust or an irrevocable trust and the lawyer didn't reserve these rights because it's common sense. People change their minds, things happen. You have to be able to change who your heirs are. What if one of them disappears on you or you become estranged or you're already estranged? You need that flexibility. You need the flexibility to change the trustee. Now, what if you need money from the trust? Let's say one day you decide you need $50,000 from that trust. Remember, the trust, you get all the income, but now you need principal. You need $50,000 to take your family and your lawyer on a round the world cruise. Very worthwhile endeavor. You can't take out principal because if you could get it, the nursing home can get it. But you are allowed to make a gift of principal to your son or daughter. Because when I apply for Medicaid, they're going to ask me, what did you take out of your name and put into that trust? But they're not allowed to ask me what the trust gave to somebody else. So you make a gift of $50,000 from the trust to your son or daughter. That gift is tax-free. Now, can they give it back to you? Well, no, they can't give it back to you because, again, if I have to apply for Medicaid, I have to show them all your investments, bank accounts for the last 5 years. If they see 50,000 came in, they're going to say, where did that come from? And if it came from the trust, you're sunk. So they can't give it back to you. But tell me, if you give them the 50,000, you think they could take that 50,000, go pay the travel agent for the trip? Well, it's their money. They can do whatever they want with it. So this is a way to get principal out through the gifting power. And remember, we can undo the trust on consent of all the named parties. So we have all this flexibility. When you really understand the trust, it's not really intimidating at all. You can undo it. You can change who you leave it to. You can change who's in charge. You can get money out if you need it. And there's no downside to a properly drafted irrevocable trust. Why don't more people set up? A lot of people say, why don't more people set it up? Well, you know what? A lot of people do set it up. They just don't broadcast it. We've done it for tens of thousands of people over the years, so we know a lot of people do it. Some people, the people who don't do it, in my experience, are people who haven't heard of it, which obviously you haven't heard of it, you can't do it. But the other thing is a lot of people get the wrong advice. A lot of people think, and this is my experience, I'll share with you, a lot of people think if they ask enough questions, they're going to get the answer. So they go around asking everybody they know. They ask their relatives, they ask their friends, they ask their financial advisor, they ask their accountant. but they never get around to asking somebody who actually knows all the answers, which is an experienced elder law attorney. And they end up getting the wrong advice because everybody knows a little bit. The financial advisor knows a little bit. The accountant knows a little bit. The friends and relatives know a little bit, but nobody knows the whole picture. And then of those who know a little bit, you know, much of what they know is not correct. Some of what they know is correct, but some isn't. And you have no way of evaluating. If I have cancer, I don't really care what my friends and relatives say. I want to know what the oncologist has to say because that's the person who knows the answer. So there you go. So I said, people haven't heard of it or they get the wrong advice. People are well-meaning, uninformed friends, relatives, neighbors, and professionals. Well, they're professionals, but they're not professionals in elder law and estate planning. They're just professionals in their field. So be careful about that. The quality of information or the weightiness of information or advice is different from different people. What about long-term care insurance versus the Medicaid Asset Protection Trust? Cost of care today, you know, maybe between $500 and $700 a day on average. So we'll say 15 to 21,000 a month. Now, if you set up an MAPT, it's not likely you're going to need long-term care insurance for the 5-year look back because you're not likely to need care within the 5 years. You wouldn't be setting it up. What insurance do you need? Well, if you're looking at long-term care insurance, and this is strictly long-term care insurance, not comparing it to MAPT, but if you're looking at long-term care insurance, how much do you need? Well, calculate your income and insure for what you're short because you're still going to have your income. So that's not going away. You only need insurance for the amount you're going to be short for the cost of care. Some people use a hybrid approach. They take both long-term care insurance and the MAPT. And why do they do it? Because long-term care insurance is very expensive. You know, $600 a day is very expensive. But no one wants to go to nursing homes. So what a lot of people do is they get long-term care insurance for $300 a day, which of course is half the cost of $600 a day, and that pays for home care. They say, I'm willing to insure half the boat for home care. But if I need facility care, I don't want to get $600 a day. I'll use the Medicaid Trust to protect my assets and qualify for Medicaid. So get the long-term care for home care and the Medicaid Trust in case they need facility care. It's a hybrid approach. There are some do's and don'ts with the Medicaid Trust. Do make all transfers to your trust as advised by us in a timely manner. You can use the trust assets for repairs, maintenance, and improvements to the house. You don't have to. This is permissive. It's not required. So your big bills, repairs, maintenance, improvements, and insurance on the house, that could all be paid from the trust. That's not taken out of the trust. So you still get all the income from the trust, but this is on top of the income. You can use trust assets to pay real estate taxes and homeowners insurance. But this is permissive. You can use non-trust assets to pay these. However, your tax deduction is lost if the trust pays the real estate taxes. That has to be paid by you personally to take the deduction. Not everybody needs the deduction for various reasons, so you can consider that as a possibility. Do take dividends and income on trust assets on at least a quarterly basis. If at the end of the year you didn't take the income, Medicaid says that's the same as if you put the money in. So it's considered an addition to principal and creates a 5-year look back on the new money that you didn't take. It's considered new money because you should have taken it, so it's the same as adding it. Do contact us when you wish to make a gift from the trust to any of your beneficiaries. There's no limit on the gift. We just need to tell you how to prepare the letter. I hereby direct you, my trustee, to make a gift to so-and-so from my trust in the amount of such and such. Contact us if the grantor needs Medicaid benefits, either for home care or facility care, or when the grantor dies. There's some don'ts. Don't use trust assets to pay personal expenses. What's personal? Utilities on the house, the cable bill, the phone bill, that sort of thing. Don't use trust assets to buy a car. Since all the assets in the trust will be exposed to liability if there's a car accident. We actually have asset protection in the trust. So we want the car outside the trust. So if there's an accident, they can't get the assets in the trust. They're sheltered. So never buy a car in the name of the trust. Don't use trust assets to pay telephone or utility bills. We mentioned that. Don't take principal or capital gains from the trust assets. That's a no-no. If you absolutely need it, gift it out to one of the children and give them the bill. They can pay it for you, but they can't give it back to you. Don't transfer IRAs or 401ks to the trust. First of all, all the taxes will become due. That's a taxable event, but there's no need to put them in the trust. They're exempt from Medicaid and they're exempt from probate. They have a designated beneficiary. Don't allow beneficiaries to give back to the trust or to the grantor any gift made from trust assets. Don't make additional transfers to the trust in the future without letting us know, because we're keeping track of the look back for you. So there you have the basics of the elder law Medicaid Asset Protection Trust. Every Wednesday at 2, I give my seminar, my regular seminar, 4 advantages of using trust. I talk about avoiding guardianship on disability. I talk about probate, what it is and why you want to avoid it. I talk about the Inheritance Protection Trust, which protects the inheritance you leave from children's divorces, losses, and creditors. And best yet, when they die, it passes it by blood to your grandchildren. Without the trust, it would go to your son-in-law or daughter-in-law and their families. A lot of people use those. We've done them for well over 10,000 clients. So that's ettingerplan.com. You go online and register at ettingerplan.com. It's Wednesday at 2, but if you're not available Wednesday at 2, you get the recording anyway. You can watch it at your leisure, so don't be shy. And as I say, if you can't make it, register and get the recording the next day. Word about our unique planning process. It's begun here today. We offer a free initial consultation. You come in with your current plan, will, trust, power of attorney, health proxy, whatever. We review it, see if it's legally adequate, see if it's personally adequate. Are these still the people you want in charge? Is this still the way you want to leave it? Give you a free copy of my book, Elder Law Estate Planning, tell you which chapters apply to you. You get a fixed fee quote. By the way, if you have any questions, type them in the Q&A now. We're going to go to the question and answer in a moment. We tell you, we don't do business really in the first meeting. We're getting to know each other, but we always tell people, you know, if you decide to go ahead, this is how much it'll cost. It doesn't depend on how much you have. It depends on what work you need, and we have a fee schedule for that. But people like to know where they stand, so we like to give them a heads up. This is the direction you're looking at. This is where we're going. Come in for a second follow-up consultation to have your questions answered. You come in for your second meeting. We answer any questions you have which arose out of the first meeting, which we discussed, but also the chapters in the book you read, might be an hour's worth of reading. We draft that estate plan together with you. We ask you, who do you want for legal, medical, financial decisions? Who's your second choice? How do you want the estate distributed? All at once, equal, not equal, spread out over time? And then at the end of the meeting, we give you a detailed 3-page written proposal. The fees are the same as mentioned in the first meeting, but now we have details of what we're going to provide. Then we ask you, what would you like to do? And now Ettinger Law Firm, I believe, is the only firm in the United States of America, only estate planning firm that does not require retainer. We examined the retainer system years ago. I was trained the same way as other lawyers. And we came to the conclusion that the purpose of the retainer agreement, and the retainer agreement is this: you want to go ahead, the lawyer says, sign the agreement and give us a check, usually for half, which is called a retainer. So now you're bound by contract and you've paid half. We don't do that, because what we found when we analyzed it was the retainer agreement is designed for the benefit of the lawyer. It's not for the benefit of the client, because when you sign, you don't have anything. You actually have a promise, and it doesn't always pan out. Sometimes the lawyer takes too long, or you don't like how they're handling it, or other issues arise, but you don't have in control. You've already signed the agreement. You paid half the money. So what we, and I think this is a breakthrough in legal thinking, what we did at Ettinger Law Firm is we realized that if we put the client in control, clearly it's the best place for the client to be. And if we're here to serve the client, and that's the best place for the client to be, we think it's the best place for us to be. So instead of a fee agreement, we replaced it with a fee proposal. We sign it, you don't sign it. And our proposal says, based on your say-so, we're going to go ahead and prepare all these documents, trusts, inheritance protection trust, health proxy, living will, power of attorney, these your properties. You come in for a third meeting. After everything is signed, you pay at the end. But our agreement says, unless and until you write us a check or hand us the credit card, you have no obligation to the firm. You're free to walk away at any time. So we keep you're in control, which is a great place for you to be. And we think it's a great place for us to be too. When we have over 30,000 satisfied clients, and partly due to that system. So as I say, you come in for that third meeting. These meetings generally 2 to 3 weeks apart at most. We review all the documents with you, you sign, and you pay at the end, either by credit card or check, and you could pay all at once, or you could pay it in 3 monthly installments. At that point, we don't say goodbye. The standard in New York is thank you very much, goodbye. I don't think anybody listening today has ever heard from a lawyer prepared their will, but we don't agree with that system. We don't say goodbye, we say hello, you're welcome to the firm. And we trademarked a process to make sure that if you have an Ettinger plan, it's going to work when you need it, not when you wrote it, I hope, decades earlier. So we keep you up to date of law changes and other matters of interest to you through our weekly Ettinger Elder Alert. We won an award for it. It comes by email. That's why it's called the Alert. It goes nice with Ettinger and Elder too. But it's our warning system. We're writing a lot about the Biden administration tax proposals. And if you're getting, well, you'll get them. I just wrote an article on gift and tax saving strategies for 2021. That will not be coming out this week. That'll be coming out next week. And if you're on this Zoom, you will be on the alert as well. So you'll get that. And then when the Biden administration changes become law, after all the horse trading is done, I will give you a complete analysis of the law and where you stand and what you need to do. Once you're a client of the firm, as I said, we don't say goodbye. We call you in every 3 years for a free review. Why? We want to see, are there any changes in your health, your assets, your family, births, deaths, marriage, divorces? So we've been doing this for more than 2 decades. So I'll tell you how it works. People come in after 3 years, not too many people need a change, but we, reestablish relationship, catch up with you. It's social. There's a real social aspect to being an estate planning lawyer. And we're renewing the acquaintance, we're building the relationship. After 6 years, naturally, more people need a change. But the reason we do it is statistically, it's been shown that very few people can get past 9 or 12 years without needing a major change. Who's in charge, who they're leaving it to, something else happens. So you do an amendment. Amendments, of course, are legal work, you're gonna pay for them. But we're still talking hundreds, not thousands. And amendments, they say statistically once every 10 years or so. So not too serious. The point is, when you go to use an Ettinger plan, it's designed to work when you need it, not when you wrote it, I hope, decades earlier. And we have saved thousands of people, countless thousands of problems with this. And it's a very nice system. At Ettinger Law Firm, we don't charge for phone calls, emails, or questions. Why? Because we want you to communicate with us without worrying about getting a bill. And once you become a client of the firm, you have this elder law estate planning firm on retainer, and you're going to need us sooner or later. And it's nice to be able to pick up a phone or send an email and get the correct answer every time, because it's all we've been doing for 31 years. And we've handled, well, over 30,000 estate plans and also filed over 4,000 Medicaid applications. So you're going to get the right answer here. And as I say, by using this program, your plan is never more than 3 years old, designed to work when you need it, not when you signed it, I hope, many, many decades earlier. How do you schedule a free consultation? I put $500 value because a lot of firms charge for the consultation. We want to keep you in control. We don't charge. We actually have more experience in a lot of those firms. So it's still worth $500. You just don't have to pay for it. It'll be with myself or Mrs. Ettinger, one of our other experienced elder law estate planning attorneys. We're 7 attorneys at the moment. They're all experienced. We don't have any inexperienced estate planning attorneys because they're of no value to the client. The consultations are available in the office. More and more people are coming in. More and more people are vaccinated. Of course, myself and Mrs. Ettinger are vaccinated. It could be by video, Zoom, or by phone. You'll get a copy of this seminar later today, in the next few hours. And you'll also get a request or an invitation to schedule an appointment online using our Calendly link. So you click on, you get our calendar, and you pick the time that's good for you. You'll get that later today. If you prefer, you can call our Director of Client Relations, Patty Brown, been with the firm for more than 26 years, can answer any question you have. She's very personable. She'll take the time with you, and she's at the 800 number on your screen. Email her, Patty Brown, pbrown@trustlaw, or text free C for consultation to the number on your screen. There we go. Now we're going to stop the share, and we're going to go to the questions, of which we have about 16. So please stay and join us. Andrea or Andrea, depending on how you like to pronounce it, M says, if an elderly parent, 94 years old, sells a second home in Florida and wishes to gift money to the children, do the children have to hold on to that money for 5 years? Oh, yes, because let's say the elderly parent has to go into a nursing home tomorrow. You don't have any look back. You would have to pay for 5 years. So gradually you can start using the money, but you always have to keep enough behind to pay for the 5 years. If you don't have enough for pay for 5 years, just keep all the money, and you have to keep enough to pay for what you could have paid. So yes, you have to hold on to it for a time. Tim R, what happens if you want to sell your houses in the trust and buy a different one? Not a problem, Tim. The trust sells the house, the money's paid to the trust, trust buys a new house in the name of the trust, and you don't start the 5 years over again. Anonymous says, if you're legally separated and bought your spouse out of the family home, do you make a trust as a single person? Yes, you do. When you say legally separated, I suppose you mean according to a written separation agreement, because that's what legally separated means. Yes, you can do a trust as a single person. Problem is, if you need Medicaid, they still consider you married. So we may want to discuss completing that, or the reasons why. Some people stay separated, but they stay together for medical insurance reasons. So we'll talk about that. So your spouse's assets may still be available for your care. Anonymous, how to choose trustees if you're skeptical of relatives squandering the assets, particularly involving a special needs trust. That's for a special needs child or grandchild. Can an MAPT Medicaid trust be set up in conjunction with a special needs trust? And can the special needs trust be beneficiary of an IRA? Well, there's a lot there, but a lot of people who have issues with family will choose the lawyers here at Ettinger Law Firm. Our lawyers will be the trustee and do it for you. We can run a special needs trust. There's an article on special needs trusts on my website, trustlaw.com, under practice areas. Yes, you can set up an MAPT with a special needs trust. You can leave the MAP assets to the special needs trust, and the special needs trust, yes, can be beneficiary of an IRA, all possible. Tim R says, if you revoke the trust, does the 5-year look back period start over? Well, no, it doesn't start over, Tim, because if you revoke the trust, there is no look back. All the assets are available forever, unless you move them out again. So the 5-year look back doesn't start over. It ends the 5-year look back, and the 5-year look back only starts over. You set up a new trust. Alonzo W says, is New York the only state where you can reverse the irrevocable trust? Alonzo, it's not the only state, but it's one of just a few states that allow that. I looked it up years ago. There are a few states that allow it. New York is a very progressive state in terms of legal planning. So we have a lot of loopholes that other states don't have. Anonymous, what if your house is an irrevocable trust? Can you sell your house and not buy another house and use the money to pay rent for a place to live? Yes, you can sell the house, invest the money, but remember, you only get the income from the trust. So the rental has to be the income or less than you're getting from the nest egg that you got from the sale of the house. So you sell the house for $700,000-800,000, maybe you get an income of $2,500, $3,000 a month, whatever it is, and you'll use the trust income for that. But also you might have your pension, Social Security, other income. So you do the arithmetic and figure out how much you could afford. Anonymous, why put money in irrevocable trust if you can't use it, but you can give it to your beneficiaries or trustee? Why not just give it to your children now instead? Well, I mentioned this. If you give it to them, Well, if you need it back, they may not give it back. They might get sued. They might get divorced. They might die before you and it goes to their heirs. So look, if there's no chance you're ever going to need the money back or you're never going to need it for your care, yeah, you can give it to your children. But for most people, they want to secure that money in case they need it later for some purpose. Mario P says, what are the major differences between an MAPT and an irrevocable trust? They're the same thing. I mean, there's 100 different types of irrevocable trust, Mario, but the Medicaid Trust is one of the forms. And when I use the word irrevocable trust, I mean the Medicaid Trust. Lise L says, is one MAPT used for a couple or do you need one for each? Well, the current estate tax exemption is 6 million in New York. If you're under 6 million, you only need one trust. If you're over 6 million, you need two trusts to double the exemption so you don't pay taxes unless you go over 12 million, 6 million for each spouse, but you have to set up two trusts to get the two exemptions. Some of you may know the Biden administration is proposing to limit the 6 million to 3.5 million. And if it's 3.5 million, if you're over that, you will also need two trusts to save the estate tax. You can double the exemption if you're 3.5 million to 7 million and save all the taxes on the second 3.5 million. You have to do that before the first spouse dies. Richard W says, what is the role of the trustee? Well, trustee is a fiduciary. They have a duty to file the tax returns. They have a duty to maintain the investments. They have a duty to keep the beneficiaries notified of things that affect the beneficiaries. But you can go onto my website and read about trustees and trust administrations under practice areas and get more details. In the Medicaid Trust, as a practical matter, the parents are living, they're competent, they handle things. You know, all the tax bills come to the house, they pay the tax bills, they pay the insurance, they do everything. The trustee in these irrevocable Medicaid trusts are generally like figureheads. The parents handle everything and they just sign. You're welcome, Rich. Thank you for the thank you. Anonymous, why is Susie Orman so against irrevocable trusts on your show when she likes them? I'm sorry. Why is Susie Orman so against irrevocable trusts on her show when you like them? She always supports revocable trusts. Well, a couple of reasons. One is Susie Orman doesn't know anything about elder law. She doesn't know anything about Medicaid. So, and also she sells revocable trusts. So she'll sell her revocable trust for a couple of grand all day long, including to a lot of people who actually need irrevocable trust. Remember, she's a financial advisor. She's not a lawyer. She's certainly not an elder law attorney. I don't know what she does or doesn't know about a Medicaid trust, but there's the problem of relying, and I mentioned this earlier, you know, so-called professionals. Well, she's a professional financial advisor. She's not a professional trust lawyer or a professional elder law attorney or professional estates lawyer. So you're getting the wrong advice. It's that simple. You know, every estate planning lawyer in the country has issues with Susie Orman because of her, you know, lack of expertise, but her bully pulpit at the same time. James R., should life insurance policy be titled to a trust? You don't have to put the life insurance policy in the trust, but very often you have to change the beneficiary to the trust. So on my death, make it payable to the trust. It passes according to the terms of the trust. Marcella S. says, do you handle estate planning for families with special needs children? All the time, Marcella. If you get a chance, go to my website, look on, which is trustlaw.com, one word, trustlaw.com. Look under practice areas and read my chapter from my book. It's there on the special needs trust and special needs children. William B. What happens if you have no one left to serve as a trustee? You have the lawyers here can act as backup trustees, not a problem. Alonzo W. says, is every additional transaction, gifts, paying out a trust, that are considered an amendment which is chargeable? No. Taking things out and putting them in a trust is not an amendment. An amendment is changing who's in charge of who you're leaving it to. That's why they're pretty rare. And Alonzo has another question. If you're in the process of selling a home in New York this year and expect to buy a home in Florida in 2022, should you wait on setting up the trust in Florida? Absolutely, Alonzo. I would recommend you wait, set it up in Florida, because you're going to be there and you want your lawyer there. If you're moving to the Southeast Coast, have a good lawyer there. Joe Karp with a K. He's Karp Law, KARP law.com. If it's somewhere else in Florida, you can go to the website of the National Academy of Elder Law Attorneys. If you have a pen, write this down, NAELA.org. I'll repeat it, NAELA.org. And you can search for an elder law attorney by zip code, wherever you're moving to. Frank F. sent in a question ahead of time. If you own a co-op jointly with your spouse, do you need to put that in a Medicaid trust to protect against nursing home access? Well, first, it's going to depend on whether the co-op allows a transfer to a trust. So you have to check with the managing agent, see if they allow a transfer to a trust, and find out their procedure and the cost. But the co-op apartment will be protected if you have a spouse, but you need a good power of attorney so we can move it to the spouse who's staying there. The one who's in the apartment is called the community spouse. The one who needs care is called the institutionalized spouse. If you want to get an exemption and you have one spouse that's institutionalized, you have to put it into the community spouse's name. And so you need a power of attorney to do that. But it's not protected if one spouse dies and the surviving spouse needs care, then the apartment is in play because you can't do spousal refusal, you don't have a spouse. So that's going to depend on whether the co-op allows you to transfer it into the co-op. And then I have another question sent in ahead of time from Rich W. If my assets and house are in irrevocable trust and need to have repairs on the house done, where would this money come from? The trust can pay for repairs, improvements, because that's not taken out of the trust, it's moving it from one trust asset to the other. Next, are RMD distributions from a qualified plan considered income? Yes. Now, the qualified retirement is not going to be in the irrevocable trust because it's exempt, but the RMDs are considered income and go towards the cost of your care. So there we have it. I hope you'll join me next week for the next Zoom side chat. I enjoy doing them. I enjoy sharing the information with you. And we hope to see you all in the office very soon. So thank you, stay safe, and we'll see you next week. Bye-bye.